But when they hit the block and pulled up, the ops was already on the car, and his partner in the car got popped in the head. Tell me why Lucci and 3 of his guys went to spin in a Maybach SUV. Returned and fired. Lucci them got nervous and manually ejected 4 of them out the SUV. Can't make this shit up. And the fans thought he was finished. You hear me?
Oh, somebody is laying out. Somebody, I don't know if he barely.
Let me connect you down the line.
Somebody just threw him out of the car.
Let me connect you to the ambulance.
He's still trying to fight for his life.
EMS, what's the address of the emergency?
Baby, can y'all please get an ambulance here? This man is dying. He's shot in the head. He just took his last breath, man.
What street are you on now? Give him your location, please, for the ambulance to get the guy some help.
What is his address? Man, this man just took his last breath, man.
Man, we have him. 679 was exactly what happened.
We don't know about me and my sister. We were just walking down the street and somebody just rolled down the street with a man hanging out the car. They just pushed him out the truck and left him for dead.
Man, I thought you said he was shot in the head.
Yes, he was shot in the head. They threw him out the car. He just died. He just took his last breath.
We have the ambulance already on the way, okay?
Okay.
And tell me what kind of vehicle. Let me go to get fire and PD and route. Tell me what kind of vehicle he was doing from, please.
White.
A white car, truck, or SUV?
SUV.
What direction did the SUV go?
His whole body was just hanging out the car.
Listen, just stay on the phone. Can you tell me if you saw any of the people that were driving the car, whether they adults or kids? Or
they were driving real fast.
I'm just letting you know how it is. It's kill time.
Yeah.
7 felony murder. That's minimum life, maximum life without the possibility of parole.
YFN LUCCI pled guilty and decided not to take it to trial and didn't tell on nobody, while YSL torn apart like a wet paper towel. They saying he the best that ever did it and got away with it. After they caught him on surveillance pulling up like a diaper, then dumping his homeboy out the Maybach. Allegedly, fans thought he was smoking dope when he turned down that 20 the first time. And Miss Fannie Willis didn't want them boys to see the light of day, but if it's a will, it's a way. At the end of the day, God got the last play. So with his time served in 3.5 months, he'll be home around May, and it's safe to say the streets been waiting on him. After that attempt on his life that was discussed in the YSL trial, from the outside looking in, it appeared that Lucci was having his way. One thing for sure, two for certain, they were standing on business with YSL.
Slime. Slime? Still slime? Oh. Fuck that shit. Fuck
Well damn, I'm trying to tell you like my hell, your boy YFN wasn't playing about no Lucci, but now the bloggers want to play with him. Like he told on something, but he was the big dog. Make it make sense. Hey look, but that's why I'm glad we got this access inside the courtroom. Stick around to the end, you go fuck around and find out. Today, shout out the Law and Crime Network.
How old are you?
32.
How far did you go in school?
I got my GED.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you're charged with the following offenses under Indictment 23 SC 188921? Count 1, violation of the Racketeering, Influence, and Corrupt Organization Act, which carries a minimum sentence of 5 years, maximum of 20 years. Count 68, violation of the Street Gang Act, which carries a minimum 5 years, maximum 20 years. Count 69, violation of the Street Gang Act. That's minimum 5 years, maximum 20 years. Count 76, violation of the Street Gang Act. Minimum 5 years, maximum 20 years. Count 77, felony murder. That's minimum life, maximum life without the possibility of parole. Count 78, aggravated assault. That's minimum 1 year, maximum 20 years in custody. Count 78, aggravated assault. That's minimum 1 year, maximum 20 year. Count 80, aggravated assault. Minimum 1 year, maximum 20 years. Count 81, aggravated assault. The minimum is 1 year, maximum 20 years. Count 82, aggravated assault. The minimum is 1 year, maximum 20 years. Count 83, possession of a firearm during commission of a felony. That's 5 years consecutive. The minimum is life with the possibility of parole, followed by 5 years consecutive. And the maximum you're facing under these charges in the indictment would have been life without the possibility of parole, plus 220 years, followed by 5 years consecutive. Do you understand that that's what you were initially charged with in the indictment?
Yes.
Do you understand that the state has agreed to no pros counts 1, 68, 72, 73, 60, 76, 77, 78, 79, 80, 81, 82, and 83?
Yes.
So Ms. Christian, the only charge under this recommendation is count 69, is that correct?
Yes, Judge.
All right, excuse me.
Have you reviewed this charge with your attorney and been advised of the minimum and maximum for the charge that the one charge that you're pleading to?
Yes.
And do you understand that you have the right to either plead guilty or not guilty to this charge? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Have you had enough time to speak with your attorneys, Mr. Finland and Mr. Banks, about all the facts and circumstances known to you regarding the charges, including any potential defenses?
Yes.
Do you need more time to speak with your attorney?
No.
Are you satisfied with their services?
Yes.
Do you waive a formal reading of the indictment, Mr. Finland?
Yes.
Do you waive any or all defects in the indictment?
Yes.
Do you understand that this is a negotiated plea, which means the state will recommend a sentence of, under count 69, the recommended sentence is 20, serve 10, balance probated, and the special conditions of probationers are no street gang activity, no contact with any known street gang members or associates, no contact with the co-defendants, Reginald Carter, Artez Carter, Justin Ushery, DeMonte Thomas, Tydrekus Glass, Rayvon Boyd, Leroy Pitts, Rondavius Hawkins, and Derek Adams. No guns or replica guns, no gang affiliation or conduct associated with gangs on social media. You must be gainfully employed and no further violations of the law. Do you understand that those are the conditions?
And Ms. Christian, I just want to make sure that the record is clear. You said this is a negotiated plea. This is a negotiated recommendation, but it's officially and formally a blind plea. I just want to make sure the record is clear.
Yes, Judge. Okay. Do you understand that those are the statutory conditions of your
Yes.
Do you also understand that you are to have no violations of state or federal laws while serving out any portion of your sentence, to include any period of incarceration, to comply with all the rules maintained by county jail where you're housed prior to being transported to any facility within the Department of Corrections where you're designated to serve out your sentence, comply with all the rules maintained by any facility within the Department of Corrections where you are designated to serve out the remaining sentence. You waive a right to appeal any and all terms and conditions of this plea agreement and the sentence imposed, as well as any right possessed in connection with OCGA 244410. And if you violate any of the special conditions, that the state is free to revoke the sentence and recommend any penalty allowable under the law, including that you be sentenced to the maximum for the charge in which you plead guilty.
Yes.
Do you understand that in exchange for this plea, the state has agreed to write a letter to the Board of Pardons and Parole stating that the state would not object to the defendant being released from the Department of Incarcerations the first time you become eligible, or after 1/3 of the sentence has been served, whichever comes first. And you must comply with all lawful authorities of law enforcement while in custody and have no further incidents from the date of this plea in any penal institution.
Yes.
And the state is recommending you get credit for time served at the time that you voluntarily surrendered yourself into the Fulton County Jail on January 13th, 2021 to present, to include any time spent on house arrest as required by law.
Yes.
Do you understand that that is the recommendation that the state is making to the court?
Yes.
Do you understand that the judge does not have to accept this recommendation and can sentence you to the maximum?
Yes.
Do you understand that if you're currently on probation, your probation may be revoked based on you entering a guilty plea?
Yes.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any government unit or special conditions of probation without being subject to revocation of the balance of your sentence?
Yes.
Do you understand that you're not allowed to possess or use a firearm while on probation?
Yes.
Do you understand that if you're not a U.S. citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at trial would, and this is true regardless of any advice your attorneys has given you?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction for trial? For example, your guilty plea may affect your right to vote, your right to hold public office, your right to serve on a jury, your right to obtain a passport, your right to receive, possess, or transport a firearm, or your ability to obtain employment.
Yes.
Do you understand that by pleading guilty to a felony, if you receive, possess, or use, or transport a firearm, you'll be guilty of a felony which carries a sentence from 1 to 15 years in prison?
You can repeat that?
Yes. Do you understand that if you plead guilty to a felony and you use, receive, possess, or transport a firearm, you will be guilty of a felony which carries a sentence of from 1 to 5 years in prison?
Yes.
Do you understand that you waive any and all defenses by entering a guilty plea?
Yes.
Do you understand that if you went to trial, you would have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, the right to testify yourself or remain silent and not incriminate yourself?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights: the right to trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to assistance of counsel hired by you, or for court-appointed counsel if you couldn't afford counsel at the trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proven beyond a reasonable doubt, the right to appeal if convicted after trial.
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter this guilty plea?
No.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes.
How do you plead to count 69 in indictment 23 SC 188921?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charge against you?
Yes.
Do you understand that you have a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that you have 4 years from today to file a habeas corpus petition challenging the voluntariness of your plea?
Yes.
Your Honor, had this case gone to trial, the state would have shown that on December 10th, 2020, this defendant, Mr. Bennett, was gifted a 2021 Mercedes-Benz Maybach by his record label. The defendant drove that vehicle and picked up his co-defendants, Rayvon Boyd, Leroy Pitts, and the decedent, James Adams. Boyd, Pitts, and Adams traveled up from Miami, but were visiting the defendant, Mr. Bennett, in Atlanta. The defendant then drove around the city of Atlanta in that vehicle. Although Bennett himself did not personally possess a firearm, he was aware that there were firearms in the vehicle, to include 2 assault rifles. At some point, defendant Bennett drove to the area of Dimmick and People Street, located in Fulton County. While traveling down Dimmick Street, After passing several individuals who were standing on the street, this defendant stopped his vehicle. The individuals on the street and the individuals in the inside of his vehicle began shooting at each other. This shooting is captured on surveillance video, and the video reflects that after defendant Bennett stopped his vehicle, co-defendants Boyd and the decedent Adams opened the door to the car and began firing assault rifles at Kevin Wright, Nathan Bedford, and others that were on the street at the time. The video shows Nathan Bedford and Kevin Wright and others shooting back at the vehicle. During the exchange of gunfire, the decedent James Adams sustained a gunshot wound to his torso that caused his death. After shots were fired, defendant Bennett drove off in the Maybach, which then turned onto People Street. The individuals in the vehicle attempted to pull decedent Adams' body back into the vehicle but were unsuccessful. As a result, they left his body on People Street and left the scene. After leaving the scene, he drove the vehicle to his father's house to conceal the vehicle following the shooting. The facts and evidence would further establish that defendant Bennett is an associate of the Bloods, a criminal street gang operating here in Atlanta and elsewhere. Defendant Bennett demonstrated his association in part by appearing in rap videos with members of the Bloods while displaying gang signs and wearing gang colors. The basis of the state's reduction, Judge, is essentially this defendant has no criminal history. We have spoken with the family in this particular case, and they have maintained throughout the course since this incident occurred that they are on board with the recommendation. They are more than amenable to the defendant's request at this point. And they have also, as you are aware from the facts, is the defendant's level of culpability in this particular incident. He was the driver of the vehicle, and he didn't have a weapon during the time of this incident. And this is out of the 80-something counts in the indictment, Judge, this is the one incident that this particular defendant is a part of. So given those things, we did take that into consideration, and that's the recommendation that we are presenting before the court.
All right. Thank you, Ms. Christian. Mr. Findling or Mr. Banks, would you like to tell me anything about your client and share anything about the plea?
Yes, Your Honor. Thank you, Your Honor. Your Honor, as you've heard, Mr. Bennett is 32 years old. Of course, we get to you in the course of a year. We've been together in this case for years. He's the father of 4 children. He assumes the task, the task of being their sole provider and taking that seriously. It's well documented what his profession is, and that is that he is a professional entertainer. I want to be clear with the court that we just didn't talk to Mr. Bennett and just take his words on these things. We've talked to literally corporate executives in California about him. We've listened to his music. You know, we've been talking to these jurors about listening to rap and hip hop, and we have spent countless hours watching videos and listening to his music, trying to see the connection it has to the case. We've employed the best experts in America on that issue, on the lyrics issue. We've employed the best experts in America on the gang issue. But most importantly, for purposes of our conversation today, and not too dissimilar from really what was presented to you by Ms. Christian, I actually appreciate her explanation of December 10th. And I would ask the court, December 10th, 2020, to really harken back to some of those hearings. I think that the court will notice that Ms. Christian's explanation of it is very different than the state's explanation 3 years ago before she was on the case, and I credit her with the accuracy of that description. I will tell the court, as we've shared with counsel, we hired literally the best civil engineers in America to analyze what transpired on December 10th. And I think it is fair to say from that, number one, not only is it impossible to with 100% certainty say who initiated the shooting, but I think it's fair to say that the argument can be made by professionals that these other people actually initiated the shooting based on expert testimony. But what's critical about that and what has transpired, we've been very open with the court, and the state has acknowledged, and that is the other folks that were involved, some of the names, I'm not going to besmirch their reputations, as the court has heard, now have literally open murder cases going to trial. One of them had been charged with a criminal attempt to commit murder. These were these other folks. And so there was a lot going on in that particular area at the time. And these are all the things that contextualize why this plea came to fruition at this time. We have really gotten to know our client's family. The court will note that his family has literally sat in that back row, dedicated to him, paying attention, being courteous to the court, being respectful to the court, being here in support of Mr. Bennett. And I think that's what the court can expect with him moving forward. There have even been people that are involved in the music world that in like fashion have literally been here, sitting in the back, being courteous, paying attention to these folks, to what has transpired here. Your Honor, given the fact that he is 32 years old, given the fact that, as Ms. Christian accurately said, he comes here with no criminal record, I know it's in the discretion of the court for me to ask for a first offender, but let me give you the logistics behind it. I know others have asked, but they've had a bunch of offenses for which they've entered guilty pleas to. Mr. Bennett comes to Your Honor, out of the 13 counts, 12 of them will be null pros. He's going to enter a plea to one of them with the court's permission. I philosophically had the honor of my first assignment was to be assigned to Judge Daniel's courtroom, who wrote the book on criminal law, the original book that we all look at. And he used to say, when I was a public defender, he used to stare at people and go, "It's my honor to give you first offender because everybody deserves a chance to get on the other side. Of course, if you commit any faux pas during that period of time, you will pay the price dearly." First offender is the proverbial sword of Damocles, and it will hang over Mr. Bennett's head for a long time. What's interesting about this offense, this plea, is that it really will take 2 decades for first offender to ultimately inure to the benefit of Mr. Bennett. And so I think that it kind of serves kind of a double purpose. One, it incentivizes him, but two, it's just not that sword of Damocles that's there for a 3-year theft by receiving probation, but something that he will have to live with because his probation, as the court is well aware, his probation literally does not kick in for approximately 7 years. And so then he's got to go 7 years and then get to the other part of that probation for first offender to kick in. And I want the court to know that we, his lawyers, have made sure he understands that first offender can be problematic. We went over the negative and positive consequences of that. Now, as with any other profession, a first offender gives you the chance professionally, and it is important in his line of work. Hopefully one day he'll be freer to travel, to try to get back to where he not only was, but really a whole other level. And first offender would give him the ability to travel in places, quite frankly, but for getting first offender, he may never get the chance to travel. As the court knows, with felony conviction, international travel becomes extremely difficult. And maybe it will take 10 years for him to go to those places, but that would be very, very important for him moving forward to be able to go to different venues he would not necessarily be able to travel to contractually have relationships with morality clauses he might not able to otherwise be able to contract to. There's just a plethora of reasons it would be important. I also, Your Honor, want to say that I think that this process has really served a purpose. This case is unique. It's a RICO case where his charges were 13 in number, but I know ultimately had 11 people in the case, and cases like this are not the normal single defendant, single count case. Unfortunately, with the complexity of a case that can last as long as three months, it takes a while for all parties, and I include our colleagues from the state, to get to the point where a resolution makes sense. And so this is really not a statement on Mr. Bennett that we're taking this, in this third week of jury selection, but really the process. And as I said in my opening remarks, this court has encouraged, I know you have your phrase of knee to knee, but you have encouraged us to remain in conversation while never saying specifically about this issue. It's been about all the other issues in the case, and all parties have taken it seriously. I think, as I said to you yesterday, if the parties look red-eyed, it's because other than the legal work we've been doing, we've been literally talking with one another to all hours, in person, on the phone, trying to bring a resolution. With all that being said, I think that Mr. Bennett truly appreciates where he is right now, and would very much, on his behalf, we'd ask that the court accept the plea as negotiated between the parties, and we're available for any questions from the court.
All right, thank you, Mr. Findling. Mr. Banks, do you wish to go on the record as well?
Judge, I would just simply say that these are very difficult cases. Having been the former director of the gang unit in this office, there are always challenges when you try these type of cases with these multi-defendant cases involving gang charges. Mr. Findling has really adequately described what has occurred between the negotiations of the parties. This was going to be a hard fall, and the state knows that, we knew that, and as a result of that, Judge, I do believe that we were able to have those kneecap meetings and come to this resolution. I do think it's appropriate. This is not a slap on the wrist by no means, because of the hard-fought battle that was going to be fought. Having said that, he's here, he's ready to accept responsibility, and I would submit, Judge, that you should accept the parties' negotiated recommendation.
Thank you, Mr. Banks. What's the state's position on the first offender request?
Thank you, Judge. We, as the court knows, we've had several negotiations. This has been a point of discussion, and we were aware that this would be a request, and not just on my behalf, but after speaking even with the DA regarding this particular issue, Your Honor, the state objects to first offender.
All right, thank you, Ms. Christian. All right, Mr. Bennett, based on the presentation of Ms. Christian, the Assistant District Attorney, I find that there's an adequate factual basis for the charges against you. More importantly, based on your responses to her questions, I find you're entering your plea in this case knowingly, intelligently, and voluntarily. At this time, before sentence is imposed, you're free to make a statement, but only if you wish to do so. Would you like to make a statement at this time?
Yes.
All right.
First off, I want to say my heart goes out to my friend James Adam and his family. Also, I want to apologize to my family and my friend for putting them through this stressful process. And I would also like to apologize to the court. And that's it.
All right. Well, thank you, Mr. Bennett. Let me just confirm with the state that the only pending charge in this recommendation is count 69.
Yes, Judge.
And what is that charge?
Violation of the Street Gang Act.
All right. For count 69, Mr. Bennett, violation of the Street Gang Act, your sentence is 20 years to serve 10 years with the balance on probation. All other counts will be null prost. There are several conditions to this plea agreement. There are special conditions and conditions on the state. The special conditions are that you're to engage in no criminal street gang activity. You're to have no contact with criminal street gang members or associates. You're to have no contact with your co-defendants, Derek Adams, Rondavius Hawkins, Rayvon Boyd, Leroy Pitts, Artez Carter, Malik Stanley, Reginald Carter, DeMonte Thomas, Tidrikas Glass, Justin Ushery, and Victor Meadows. You're to have no guns or replicas of guns. You're to participate in no gang affiliation and or conduct associated with gangs on social media. You must be gainfully employed. And for purposes of the definition of employment, since you are an entertainer, self-employment would come under the context of employment. You're to have no violation of any state or federal law while serving on any portion of this sentence, including any period of incarceration. You're to comply with all rules maintained within any facility of the Department of Corrections where you will be designated to serve out this sentence. You will waive your right to appeal any and all terms and conditions of this plea agreement and the sentence imposed, as well as any right that you possess in connection with OCGA section 24-4-410. I'd like to ask both Mr. Findling and Mr. Banks if this term is agreed to by counsel as well.
It is, Judge.
All right. If you violate any term or condition of this agreement, including the special conditions, the state will be free to revoke this sentence and recommend any penalty allowed under the law, including but not limited to the maximum sentence provided by law. As a condition of this sentence, the state has also agreed, and I believe this is the first time I've ever seen this, the state has agreed to write a letter to the Board of Pardons and Parole stating that the state will not object to you being released from the Department of Corrections the first time that you become eligible for parole, or after serving 1/3 of your prison sentence, whichever comes first, if you comply with the following conditions. You're to comply with the lawful authority of any and all law enforcement. You're to have no further incidents from the date of this plea in any penal institution. You are to receive credit, and I don't do the credit for time served, but what I will acknowledge is you have been incarcerated since January 13th of 2021 to the present. Is that correct, Ms. Christian?
Yes, Judge.
And Mr. Findling and Mr. Banks, do you agree with that date, with those dates?
Yes, sir.
All right. Have I adequately detailed the recommendation, Ms. Christian?
Yes, Judge.
Mr. Findling?
Yes, Your Honor. I just want to ask just one fact on the first offender. I know there was an issue with a co-defendant, but the court would note that co-defendant had a plea to a voluntary manslaughter charge, which the court in an uncomfortable position for requesting the first offender on voluntary manslaughter. It's a difficult ask. We're not similarly situated.
All right. And the court has considered the first offender request, and the court is denying the request at this time. All right, anything else? Have I adequately detailed the recommendation, Mr. Banks?
If I may, Judge, as a part of the negotiated recommendation, the state has agreed to no pros indictment number 22 SC 180737, as well as decline to prosecute case number 23 CP 216278.
Is that correct, Ms. Christian?
Yes, Judge. I was going to present that at the end of this.
All right. So is there anything else before I bring probation on to get further instructions from the state, Ms. Christian?
Nothing else remaining on this.
All right. Anything else, Mr. Findling or Mr. Banks?
No, Your Honor. It's just been done.
All right. Officer Smith, go ahead and unmute your microphone, please.
Yes, Your Honor. Before Mr. Bennett when he is placed on parole or when he is released on parole, he'll be given reporting instructions at that time. If he resides in another state, they will process the transfer of the case to the other state, but he will be given full and complete reporting instructions prior to his release from the Department of Corrections.
All right. Thank you, Officer Smith. All right. I'd like to just echo Mr. Findling's earlier comments about the professionalism exhibited by the attorneys for the state and the defense in this case and this process as well. Although it's not been easy, all attorneys have exhibited the highest levels of professionalism. It's greatly appreciated by the court.
Thank you.
All right, that completes the sentencing for Mr. Bennett. Thank you.
Lucci defense team was in there cooking, I ain't gonna hold you. He got stripped of a lot of rights, but at the end of the day, he called cool because that deal was sweeter than bear meat. I feel it was a smart decision for him not to play hardball and go ahead and get it over with, you hear me? Because that 911 call conflicted with what was said in court. In court, it was said James died from a wound to the torso, and in the failed attempt to pull him back in the car, they left him on the scene. But in the 911 audio, the caller said he was dumped on another street. Pop in the comments because I really like to hear how y'all feel about this one. Do everybody deserve a second chance? And I'll catch you in the next one. Kids, stay in school and listen to your parents because this ain't what you want. Drill Time TV, I'm out.